For those of you who are joining us, good afternoon. I'm just going to give folks another minute to join us before we get started. Good afternoon, everyone. I'm Erin Zach, the Director for Alumni Engagement, and I would like to welcome you to Connecting with Canisius, our Lunch and Learn webinar series. The title of today's webinar is Planning Your Digital Exit, presented by alumna Honorable Asa Mosey. I can tell by the number of registrations, over 100, that this is a very popular and significant topic. Joining us today are alumni, faculty, staff, and parents, and I welcome all of you to our program. I would now like to introduce our host and moderator, Mariah Propus. Mariah, a graduate from the class of 1991 and a member of the college's Board of Trustees, is Senior VP and Director of Distribution and Broker Partnerships at All Risks Limited. Mariah, I'll now turn the program over to you.
Thanks, Erin. So good afternoon to all of our participants here. I'm always excited to participate in our Connect with Canisius webinar series. And this topic is particularly relevant to my own career, as cyber liability products and programs have been the fastest growing, most dynamic sector of the insurance and risk management industry, both domestically and globally, for at least the past decade. In addition, at Canisius College, we've continued to focus on program investments in the science and technology fields, and we're proud to provide Western New York's only technology-based master's level cybersecurity program. So this is an incredibly on-point topic today, and we've got the leading subject matter expert lined up to walk us through this complex and challenging digital landscape. It's such a privilege for me to introduce today's speaker, the Honorable Asa M. Mosey, Erie County Surrogates Court Judge. Judge Mosey is a lifelong resident of Western New York. She earned her bachelor's in business administration degree from Canisius College in 1992, and then graduated with her Juris Doctorate in 1994 from the Thomas M. Cooley School of Law in Lansing, Michigan. Judge Mosey was admitted to the New York State Bar in March of 1995. Judge Mosey was a founding partner with the firm Mosey Associates LLP, formerly known as Mosey Persico LLP, also located in Buffalo, New York. She previously served as a commissioner at the Erie County Water Authority from May of 2000 to May of 2006, being the first woman to serve as commissioner. Having practiced as a private attorney in surrogate court for over 20 years, including 14 years as Erie County Public Administrator under former surrogate judge Barbara Howe, Judge Mosey was elected as New York State Surrogate Judge for the County of Erie in November of 2017. Judge Mosey is currently serving her first term on the Canisius College Board of Trustees, and I'm so pleased to serve the college alongside Judge Mosey. One quick housekeeping item. We received so many advanced questions for this session. Thank you so much to everyone for taking the time to send those in to us. I will be posing these to Judge Mosey on your behalf throughout our presentation. If you still have questions when we're finished, please submit these through our Office of Alumni Engagement to Erin Zach, and we promise that all of your questions will be addressed as a part of our follow-up from this webinar. So with that, let me turn it over to Judge Mosey. Thank you.
Ms. Probus, thank you so much. And Ms. Zach, without both of you, this program would not be possible. And we appreciate all of your time and energy and efforts towards making this successful. I also wanted to clarify, it's my fourth term on the Board of Trustees. I rotated off when I was running for this position, but I am a longtime member of the board. And the other thing that I would like to, if we could, somebody has requested, Ms. Zach, that we put this on closed caption, if we allow the closed caption prior to us starting the program. And all of the materials were handed out before this program started, the outline. These slides, so everyone knows, will be provided to you after the program. So if you want to take notes, of course, take notes, but don't think you're not going to be provided all of the materials and we will make sure that those are provided shortly after the program ends. There is an awful lot of information here. This program was put together originally for a 3-hour continuing legal education class. When I started trying to narrow this to a 1-hour program, I decided that I didn't want to do that. I wanted to provide all of the information to everyone, and we'll get through as much as we can. We'll highlight some things, but I didn't want to short anyone on the materials. So we're not going to cover everything in the detail that we normally would. Please feel free. I am fine with interruptions. If you type something in the chat room, Ms. Propus, if you could feel free to any time let me know if there's any specific information that somebody is asking or requesting, and I will stop and we could address that. First, what are digital assets? Now, you would think that we would all know that in the world that we are living in right now, but it's everything. It's social media, it's Bitcoin that people would understand it's blogs, it's vlogs, it's websites, it's domain names, it's affiliate markets, games, investments, genealogy information. It's a lot. It's everything. It's what we're storing on our computers and our phones. Our phones are never this far away from us. I'm sitting here doing a presentation and we have our phone here. If I were to open this, I have it off, but if I were to open it, I have screens and screens of apps. I have money that are saved for my Starbucks. You have money that is in forms that are digital. And it's so important to recognize all of these things that are digital, they are not able to be received unless we give the information to somebody. We give the code for our phone to someone. We make sure that we have made our passwords available to people, that if we have usernames that are on our phone or computer, that they're given to somebody that we want them to be given to, because there are laws that we would have to overtake in an event that somebody passes or someone's incapacitated, and we want to try to get that information. If we haven't made sure that that is done in advance, there are things like the federal privacy law. There are terms of service agreements, and they are not easily overturned. There are many unknown account login information that we would have to compete with. There are passwords that are encrypted. Now think about just the money that you have on the apps that are on your phone. It could be hundreds of dollars, thousands of dollars, hundreds and thousands of dollars, and millions of dollars. You have no ability to get this information to someone unless you have decided in advance. Most online accounts are password protected. Most passwords can be reset only if you have access to the actual account holder and their email information. So you have to go into one thing that might be password protected to get into another thing that might be in order to restart something. And you can see how difficult that is. In 2015, data from research polls found that the average internet user has approximately 90 online accounts. We tried to get the information updated, and there's varying information, but now they are saying that we are approximately over 200 accounts now in 2020, 2021. And that's staggering. And that's every individual person. And oftentimes there are different passwords that are used. When you're trying to retrieve this information, it becomes very difficult retrieving unknown login information. We might need to have specific questions that we would need to answer, and we still might not be able to get the information. There is also federal and state privacy laws that we would have to compete with. There is the Computer Fraud and Abuse Act and it's still in place, and that was from 1984. It prohibits unauthorized access to computers. It protects against anyone intentionally accessing computers without authorization. The act largely believes to be outdated, but we haven't really updated that as of yet. And you could see that electronic computers and privacy acts that are stored, there's an extended restrictions on government wiretaps of phones and calls that include electronic transmission. So you have these competing protections. So people want to protect this information. The state and government laws are here to protect the individuals that are storing this information that is electronic. But at the same time, what if we want that information to have access to somebody if we can't be here and do it ourselves? So you have those competing issues, and that's going to be sort of an underlying theme throughout the entire seminar. There's also the terms of service agreements. And these terms of service agreements, which you'll see throughout the seminar and the outline, are going to be referred to as TOSs. This slide, the outline, all the information that's being provided, I want everyone to think about when you open up an account and you're trying to get a new app or you're trying to get a new account going, you have pages and pages of information. I'm a judge. I was a practitioner for years. You know what I do? I scroll down to the end and do agree, because I don't want to sit there waiting, reading all the information. I check the box. I do it, just like everybody else probably does it. And then you have no idea what you just agreed to. And part of what these agreements say, they can change the information whenever they want to. And they might send you updates, they might not. You might be obligated to go back in and see if the terms have changed. Are you going to go back in and start checking every month, every few weeks to see if those TOSs have changed and if you're in agreement to them? Now, there are many states that have overrode these agreements, but that's in litigation posture. Do you really want to be in the midst of litigation on something and spending time, energy, and money? Or do you just want to be cognizant of it? And later we'll go through showing that many of these TOSs, you have the ability to go in and designate someone to have the rights to get into and to provide your passwords. So how can fiduciaries administer digital assets, and what statutes govern digital assets specifically in New York State? Now, that is a huge question and is constantly changing, and some of these laws also change. Now, the EPTL, which is the Estate Property Trust Law, so this is what governs in our court. And this is when you have a will, and it's under section 13, and specifically 13A applies. And fiduciaries acting under a will, a trust, or a power of attorney is where that's going to fall, and guardian ad litems and trustees and custodians. Users can utilize online tools to direct a custodian to disclose designated recipients for all of the contents. If a user does not use the online tools, then that person is responsible to try to get that information, and it's not easy. When you have a custodian and then you have their TOS agreement, you're going to have to abide by the TOS agreement, and you might not be able to get that information. Now, service for providers and the tools that they use, you have custodians may provide online tools that allow users to be specific that who can access and who cannot access their information upon death or capacity. So within those actual providers' information, you can go to and look at the specific terms and if you have a person. And I'm going to try to jump out of this and get into, and I'm going to stop sharing for 1 minute, and then I'm going to go back into and share this addendum or appendix that you'll get. So these are all the different providers that are the most common, and their terms of service agreements, and if they're available or not to designate somebody to get the information. And that's Facebook, Instagram, and you're going to get this provided to you when you get the outline. It's the attachment. And you did receive the outline, so you should have gotten this as the appendix. You have Twitter, you have LinkedIn, Snapchat, Pinterest, TikTok, YouTube, but look at how different all of them are. They all provide different things. They're not all the same. They're not giving you all of the same rights. So you don't always have everything that's going to be easy, which is why I implore people to provide the information beforehand. And that's before you obviously have passed or incapacitated. And you could do this in your estate planning on top of doing it when you're accepting service providers and different people. And at this point in time, we're going to be going on to another section. And Ms. Propus, I believe that there were some questions that have popped up.
Yep, absolutely, Judge Mosey, thank you. So I'm going to pose really 2 questions here at this time. First one, at what age should one begin to plan their digital exit? And why is this important?
Well, that's a wonderful question. When I was an estate planning attorney before I became the surrogate judge in Erie County, and used to talk with individuals about when you start doing your estate planning. When you have assets, first of all, you need to be 18 to sign an actual will, but you can have directives before that. And I would tell people that anytime you have something that happens in your lifetime that triggers a big change. So you win the lottery, you'll lose a loved one that might have been part of your estate plan. You have a child. So any big events in your life should trigger you to look at your estate plan. And any time that you have assets that you are worried about and how they would be distributed upon your passing, that's when you start. But the bigger question is, and more so the bigger answer would be, when do you look at it again? So if you have an estate plan, you have a will, you have a trust, you've provided all of this information to individuals, you've allowed access to the digital assets, you've determined where you want all of your assets to go upon your passing. Anytime in your lifetime that there's a significant change, whether it be good or bad, you should go back and look at those documents. That will, those trusts, any codicils or addendums, any documents that you have, powers of attorney. I mean, almost common sense. If the person that you've named in your estate, in your will, to get most of the assets, pass away or become disabled, and you don't want that money going to the state, and they might become dependent, and therefore anything they received might be subject to a lien. So you want to look at, as soon as you have assets you want to protect, but then you want to continually throughout your entire lifetime look at your estate plan whenever there's a significant event in your life. Do you feel that that answered the question, Ms. Propus?
Great. Thank you, Judge Mosey. And I want to pose another question that just came in that I believe is right on point with where we are in your presentation. The question here is, what section of EPTL would govern info access in the case of an appointment of an administrator when one has passed without a will?
So that is going to be under the 13 also, but that's going to be under intestacy law. That's when you don't have a will. So this is all considering if you have or you don't have the will. The only way, and that's why we focused on when you have a will, the only way you can allow access is with a will. So I don't really believe intestacy without a will cover that at all. Because with a will, you're directing somebody to have the ability to access. If you don't have a writing that the court would be able to submit into the court itself with directives, then I don't feel that there's any area at this point in time in the intestacy section that would allow access, because there's no way of having a directive without the will. So I know that's sort of a circular answer, and sad that we don't always keep up with the times. And maybe there should be something proposed to talk about who has access. Now, once you get appointed, and let's say it's an intestacy and you're a fiduciary, once you get appointed, you can then write letters to people, explain to them that you have the authority, and you could actually bring the suit in front of the judge that can then order the turnover. So you'll see some of these cases that has occurred. And because of the lack of time and the amount of materials, I'm not going to go through the cases specifically, and I'm going to skip ahead to the next sections. Are there any other questions on this section, Ms. Brokus?
Just one more to pose at this time.
Please.
And I think, again, this is a great on-point question. What problems are we most vulnerable for, knowing some of that's going to be addressed in the case law examples, but are there gender differences in vulnerability to be aware of?
I would say we haven't seen it very highlighted or specific with gender differences, but I think gender differences are apparent in everything in the law. So if you have more, let's say, females that feel comfortable in disclosing their passwords and things to family and friends, and men might be more hesitant in giving up control. But I think that is flattening. I think that people are recognizing the law as it stands, and I don't think that it is coming into play, at least that we have seen.
Okay, excellent. Thank you.
But that was an excellent question.
Thank you.
Any other questions on this section?
Not at this time.
Okay. And I'm going to again skip over all of the cases, but you will be provided that information. And we're going now to the section that you have. It will be page 18 of your outline, and that's the recent cases in law interpretation. That's the areas that if you want to start reading those cases, and that was from page 11 through page 17. And then we are going on to Revised Uniform Fiduciary Access to Digital Act, and that is the RUFADAA. It was a development by the Uniform Law Commission to provide fiduciaries with a legal path in order to manage their digital assets. And as of actually 2021, it says 2020 on the bottom, The only state that has still not enacted this or recognized that we need to put something in place for people to be able to have some sort of access is Louisiana. And that is to date, that is current. And again, we do now have from page 18 through page 21 additional cases, which I'm going to have you take a look at on your own. Now, let's go on to preventing identity theft after death. Accounts that are not regularly monitored for spam or phishing or other cyber attacks make a user's identity very vulnerable. So do you see how on one hand, we want to give access so people can get access to your assets that need to in order to collect them? But on the other hand, you have other issues that come up that if you are providing access, there's other things to worry about. Identity theft is a huge one. At times, it can take up to 6 months for financial institutions, credit reporting of Social Security or any identity thefts or registering of death certificates. That's a long time. You could lose everything in 6 months. And these are some of my favorite examples, and I want to spend a little bit of time on this. Digital resurrection. And you see some people here that you recognize. There are post-mortem privacy issues and reputation issues. If you ruin or tarnish someone's reputation, that's an asset. And especially you see the people that I have on this slide, and you can imagine how much value there is. There are digital resurrections that have occurred. James Dean died in 1955. Finding Jack was a film that was released. And I know the chat room's going on, and I'm going to come back to that. When was that released? If anybody knows that, please let Ms. Propus know. James Dean died in 1955. He is the star of a film called Finding Jack. Now I'm going to go to the next one. Rapper Tupac passed away in 1996. And he has released, think of this, 6 albums. Post-mortem, 6 albums were released. All of those albums were digital. 5 of them became platinum. So he passes away in 1996, and he starts releasing albums that go platinum. How much do you think that's worth? What if they didn't have access? What if it was password protected? Where is his family going with this? How does his fiduciary that's responsible for his estate tell the family, I can't find them? I don't know where those albums are or those songs. Nobody has access to them. Whitney Houston, who passed away in 2012, is going on tour this year. 2021, she's going on tour. They have a virtual tour with Whitney Houston. That they are actually, it was supposed to be 2020, but it was delayed because of everything that was going on with COVID. I'm gonna be going to Whitney Houston's concert, so everyone knows, but she passed away in 2012. And again, it's only because she allowed access. Did anybody come up with the answer, Ms. Propus?
They did not, but I have the answer.
Oh, you're the best. When did Finding Jack, who stars James Dean, who died in 1955, when was that released?
In 2020, and it was quite controversial in Hollywood.
Absolutely. It was very disturbing and very controversial. Can you imagine how many people that are stars today said, wait a minute, by the way, no one had the right to be doing this as far as the stars thought. James Dean had no idea. He is not gaining at all. They took clips from other films that are open to the public and they used them. And they made this film and they received nothing from it. And that's why it was so scary and so controversial. Now, Robin Williams, on the other hand, and you see his picture here, passed away in 2014. He had very specific language that included restrictions that no one was allowed to use his likeness in anything following his death for 25 years. And he died in 2014. So at least until August 11, 2039, no one can use anything of Robin Williams in any of his stand-up, in anything, until August 11, 2039. There was furthermore a provision in his estate, and this was all of his actual digital films, pictures, recordings, all were put into a trust. And there is a foundation. And now that trust has the ability to be the only one that has the right to and the access for all of these films, all of these pictures, everything that was digital. I can't imagine how much that's worth. All of Robin Williams' stand-up, everything that he has done, and he made sure that it went the right way and prevented anyone else from doing anything. Preventing a decedent's life story to be given away when you're a public person, when you're famous. So that's also something that needs to be protected. So again, the ability to have access on one hand, and the reason why you want to protect these things on the other. And it's such a balance. Now, that would end our next section, Ms. Propus, if there are any other questions that
Yes.
you wanted to pose.
Thank you. There are several. So duly noted on digital resurrection, and wow, on right to privacy post death. So along these lines, is it illegal for a loved one to access information if a person's user ID and password are not frozen at the time of death?
Oh, did I write this question? Because it's one I am so happy is being asked.
Yeah.
So this is on paper, I chose one person, but I'm really close to my roommate. So they know everything and they go in and out of my computer. So my estate plan, or if I don't have a will, everything's supposed to go through intestacy or through the will. So you have your family, your parents, your siblings, your spouse, who sometimes is the one that you lock out of your computer. So they don't have access, or significant others or your children, and you don't want them to see things. So they might be locked out, and then somebody else might have your codes and they might have the access. So it's not legal to do anything after a person passes. However, there were arguments in some of the case law that the person that had the actual passcodes, passwords, or encryption information are the ones that the person intended to have the asset. And there's been cases where that's been argued. And thinking about things, like the cyber currency that we're going to go on to next, and the cryptocurrency, there can be millions of dollars, Bitcoin, when you have a code. You can't get to that. It's gone forever if you don't have it. So if the person that has the code should technically, like, you shouldn't be using somebody's ATM card after they pass away because you know their code. You shouldn't be, but there is an argument that the person meant this individual. That's why they were given the codes. So it's a very hyper technical and would be a full blown out hearing more than likely. The real question, Ms. Propus, is who knows? Does the family even know? Does the person even know that the individual left the computer on before they died, and because it was on, the passcodes weren't necessary, and then somebody else found those assets? Again, it's why it's so important to put it in your estate plan. Because if I list out that I've got $3 million in Bitcoin, they're going to know to look for it. If I don't mention it and I'm a recluse and I don't even tell anybody anything and I don't trust anybody, then it might be lost forever. Does that answer the question, Ms. Propus?
Yes,
Okay.
thank you.
Is there any other questions on this section?
Yep, I've got two related ones, Judge Mosey, and I think I know the answer to this one now, but I'm still going to ask it, and one also came in through the chat function. If you leave your sign-in credentials for your survivors so that they have access to your social media sites, what is the right way to notify administrators of the sites that I've passed away? And furthermore, what happens if you leave access to social media to your survivors, but they don't have the passwords to access any of your online properties? Then how is that information accessed?
So I'm going to take the last part of that question first. It would be the individual provider, like Google. And if they know that you have the right to the access of it, they can restart the password or provide something to get to it. However, you would have to prove that you had the right to get that information. And there's some really good cases. And one of the things I would like people to think a little bit about is, what do you want your family to have access to, or the fiduciaries of your estate or trustees? Are there things that you don't want them to? There's a heartwarming case that was provided that we already jumped past, about a mother wanting to know the state of mind of her child that committed suicide and wanted access. And it went all the way up to the appellate division. And they did allow some access, but it was very restricted and limited. And she wanted to know if there was anything, and including pictures and other things that she had requested. But then you also, as heartwarming as that is, you can understand why these companies want to protect our privacy. Because when it's known that something was provided without a fight, or they just gave it to an individual that asked, I'm not going to use their site anymore, because I might not want anybody to have access to certain things and certain pictures and certain private conversations that I've had with people. So that was, my take on it. But the other part of that, I'm sorry, Ms. Pope, was the beginning of that one.
If I leave my sign-on credentials for my survivors so that they can access my social media sites, what's the right way to notify the sites, the administrators of these sites, that I have actually passed away?
So the fiduciary, whether it be intestacy and somebody that has the right to petition to become the fiduciary if you don't have a will, or the named administrators, fiduciaries of your estate under naming them as executors, or executor, they would provide the information. And some of those providers, which is in that appendix, you could actually go in and give the name of the person that you're authorizing. So if you go to any of the providers and they have the ability to name somebody, you can go in and name the person to allow them access when you pass. Then the person only has to provide their identification and a death certificate. And then the information will be given. Any other questions, Ms. Propus?
No, understood. I just think the security and privacy implications here are just absolutely fascinating. So thank you.
And I have left up this slide while we were having discussions so people could really think about it and look at this. It's the Bitcoin. It's the, cryptocurrency that has been created since 2009. This is so complicated. There was an entire program put on at the Judicial Institute for the surrogate court judges that was a full program regarding this. And frankly, my head still spins when we come to this. It's just so difficult to wrap your head around that there is currency that isn't fungible. But I'm from a different era than a lot of the people that are on this program today. And this is becoming more and more common. So this isn't just the pictures and photos and music and things that you have, or apps where there's a couple $100. This is a lot of money. And this was an article that was just put in, that we just got from the New York Times, but it also has appeared in many other places. So this was $69.3 million of assets that were virtual assets, $69.3 million. I was floored. We talk about it, we discuss things, but this was all virtual. This was all digital. And, the more and more we all want to be paperless, and we do, and we talk about wanting to be paperless, the more we want that, we strive for that, the more this is essential that we look at all of these things, not only that we do, but anyone out there that's going into law or going to be an accountant or a financial advisor. This is part of your life now. You have to really be thinking about this and really understanding the effect for what will be potentially your clients. So digital asset planning. The safest way for a user to ensure their digital assets are taken care of, and this was a really good question earlier. So this is more of the structured written answer, is to utilize online tools that are provided by providers, express designations in their will. So I'm pretty sure that we covered that through one of the questions. And then the testator or the individual that is a fiduciary, if there is not a will, can consider appointing a digital administrator or employment of a digital asset manager. So what that means is you could, in your estate planning, say, I want my sister, who is the most techie of all of us, to be my digital administrator. I can appoint somebody else, like my husband, as the executor of the estate. So there can be now different people. So a digital administrator is almost like a trustee. It could be a separate person. And it can be somebody that you have chosen to take care of all of your digital assets. It could be a friend or a relative, again, somebody that's more tech savvy. You might have your parents as the executors, but you might want your siblings as the digital administrator. And we also have provided language. If you throw out all of the other slides and the outline, you'd hurt my feelings, but that's okay. But I would keep this one. So this is language that has been suggested that you could use when you have electronically stored assets. And it shows you that example of how detailed they're telling you to be. You know, they're going to tell you what's stored. You're going to let the people know that there's a directive to allow access. And you're going to let them know who you want to have that access. So keeping this language would be important. And that is I'm going to just keep going, Ms. Propus, unless you think that there's another question.
No, let's do that. I've got two more, but they actually could be posed at the conclusion as well.
Wonderful.
So let's keep going. Thank you.
There are electronic wills and the statutory compliance. The reason that I kept this in, even though right now we are not one of the states that have the electronic will, it's very confusing right now because we have executive orders that are allowing during this, when we had the pause and during the time with COVID, there's actual executive orders that had not been made into state law yet in New York. And that's in reference to virtual will signing and virtual notaries and being able to do everything virtually. That has not been adopted. However, and there's more cases that I'm going through. However, the virtual will signing and the virtual notaries are being brought to the state legislature and being proposed by the administrative board for the surrogates. It's advisory board statewide. I am fortunate enough that I sit on that. And we are going to be proposing that some of the things that happened during COVID be adopted as actual law in New York State. One of those things that we are talking to the practitioners about is what they think about virtual notaries and what they think about virtual will executions. But as of today, we do not have a state law that actually allows it, though we have an executive order that does. So yes, I think there's a question.
Yeah, and the question, Judge Mosey, is on provisions in other states. So I did respond to that saying we do have some of the other states referenced and included in this presentation when it's law that's also applicable in New York, but the majority of this is focused on New York State for this presentation. But if there's any comments,
correct, there's only 4, and I have a slide for each one of them, and also in the outline they're covered, but I skipped over that because of time. But once again, why I wanted to provide all the information to everyone. And Florida is one of the newest. Nevada is probably the most lax. But there are only 4 specific states that do. Now, with the big issue with electronic wills, and now with the executive order allowing them to be virtually signed and stored, so there's no hard copy, the real question is, how are you deleting it? We all know everything is saved all the time. So as practitioners, this was one of the biggest questions that they had. Like, how are we going to handle if we want a new will? We have the cloud that, backs files up. It's really going to be difficult with e-wills to delete them. And any of the practitioners in our area that practice here at Surrogate Court know that if you have a prior will and there is anyone that is adversely affected, they then become part of the whole proceeding, and you have to include them. So though you've deleted them out, you have to include them. So if we can't find a way to get rid of these wills completely and say they're deleted, there might be some problems. And then here, and then we have storage issues, and some questions about the ceremony itself and the witnessing and how to submit these or have them admitted into probate. Here is the answer to the one question the other states. I've delineated these out. These are the states that allow the remote and virtual execution of wills and electronic wills and storage. So it's Nevada, Indiana, Florida, Arizona. So we do have those, and you can always go back and take a look at those. Okay? But again, because of the time that we have, I just wanted to make sure that I address any specific questions. And I know that we only have 10 minutes left. So Ms. Propus, if there's any other questions, I feel that everyone can read outlines and look at slides. So I'd rather have the questions asked.
Agreed. Excellent. Thank you, Judge Mosey. So here's another good one. Do you recommend consolidating information in a password manager? And I'll share with you from an insurance perspective, my insurance risk management colleagues are very particular about which password manager is being utilized. So we encourage, insureds either for their own personal identity protection or in the case of a corporate program, to make sure that they work with our risk management team first to make sure that it's encrypted and that it actually passes what we're looking for in terms of risk management priorities. But I think the legal perspective is also important here, Judge Mosey.
I think it's the same as what you had said in a nutshell. That is exactly. And you have to be very particular, and you do need to make sure there's encryptions. But the one caveat, you have to make sure it's updated too. And frankly, oh, and we have a window washer behind us. But frankly, it's hard to do sometimes, right? You have to update that manager of your codes, because every 6 months I get a different request on a different computer for whatever app I'm using or whatever password I have. And you'll oftentimes have to change it, and it can't be anything that you've had for the last fill in the blank, 6 months, 2 years. So you're using all sorts of different passwords all the time. And if you don't update those and you don't let the manager know that, then you're in the same position as if you didn't even have someone.
Yep. Agreed. Thank you for that. I would say, for the individuals on here, if you have an identity theft prevention program through your bank, which is where a lot of private individuals access this, they have lots of resources available with specific guidance on the correct choice of password managers as well as maintenance of that. So that's a great place to go. And you're entitled to that level of support services and risk management when you have one of those programs in place.
Agreed, Ms. Propus.
Thank you. Thank you, Judge Mosey. So one other great question here. I love this one and totally agree. So regardless of age, this is an important conversation to have. But relative to young adults, how can one start to approach this topic with our young adults? And what's the right way to think about initiating that conversation with our young adults?
That's a great question. Young adults are probably the ones that need it the most. And I mean, frankly, are the ones that probably know the most about these digital assets and the passwords and how to protect them. So I think now is the time to start explaining to young adults that you have things that you might not want me to have access to now. I get it. But please make sure that if something were to happen to you because we care about you, that we have access and it's somewhere and it's taken care of somehow. And you let me know. And if that's put somewhere that they don't have access during their lifetime, because I don't want my parents or my friends or my family to see certain things while I'm alive, but I definitely know that I absolutely unconditionally want to make sure they have access when I pass. It's important to have that conversation as soon as possible. You know, it's a hard one though. People, I mean, people start thinking of their mortality or saying, oh, how could that happen to me? Or why would I provide that to you? And why are you asking? It's a tough dialogue to have. But that's an excellent question.
Agreed. Thank you, Judge Mosey. We had a couple other questions that were pre-submitted, but frankly, they were addressed during your comments and your remarks. I also want to point out, everybody stayed with us for the entire hour. So another great testament to how fascinating this information is. And as well, I did pose a question here in the chat function. If anyone has any final questions, we would welcome them. Erin, I know we've got some reminders to all of us. You know, I'll continue to point out that this information is available to everyone. Another great part about having Judge Mosey with us today. So we'll make sure that all of the information gets to all of you. It's such important and relevant reference information. But without any final questions, we've covered everything that was pre-submitted and then some. So thank you very much.
No, thank you. And I know there was a lot to cover and I went very quickly. But again, I wanted to make sure that we went through and covered all the materials. Everything that is in here that you have been provided, the outline and soon to be, and I believe, Ms. Zach, you also provided the article.
I did, yes.
Okay, so now we will circulate the PowerPoint, and they do go hand in hand and you can follow along with them. And it provides you all of the information that we just went through here today. And once again, with the thanks to Ms. Zach for putting this together and so many other wonderful, wonderful programs. And to Ms. Propus for keeping everyone on task and moving this along and making it interesting. Thank you both very much.
Thank you so much, Judge Mosey. And in closing, I'd like to acknowledge our moderator, Mariah Propus, for joining us today, and also thank our guests for attending today's webinar. I hope everyone has a lovely afternoon, and I will be sure to send out the slides by tomorrow so everyone has those. And we also have recorded this, and so once the recording has been edited, I will also send that out to all participants as well if you'd like to share with your friends and family. So again, thank you everyone and have a great day.
Thank you.